Good morning, everyone. I'm Hayward Dykes. I'll be the special magistrate hearing the matters this morning. I'm going to call to order the December 10th, 2025 magistrate docket. Anybody who plans to speak today to present testimony or evidence, I'll go ahead and ask you to stand now, and I'll go ahead and swear everyone in at one time. If you don't plan to speak, you don't have to stand. If you think you may want to stand. Doesn't mean you have to speak. All right, so raise your right hand. Do you all swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? All right, thank you all. You can have a seat. The first matter we have on the docket this morning is Burks, B-U-R-K-E-S, Beach Services. The allegation or claim is failed to clean up after bonfire. And we have Officer Guard. Okay, Officer Guard, is there anybody here on behalf of Burks Beach Services? All right, if you don't mind stepping up. We have microphones here. Yeah, you can just grab a seat. What we're going to do, we only have one other matter on the docket this morning, but we'll allow the county to present. Then you can ask any questions of the officer, present any evidence or testimony afterwards. All right? All right. All right. Thank you, sir. All right. Officer Guard, whenever you're ready to begin. Check it. Just tap it. No. Try it. Now try it.
Hello?
There you go.
Yes, sir. On 10/18/2025, responded to a complaint of bonfire remnants left on the beach. Upon arrival at 7:27 a.m., I observed a smoldering bonfire pit at the location, GPS location, 30.348946 north, 86.240972 west. I took photos and body cam footage of the bonfire pit smoldering with glass bottles inside the pit. I then removed the pit and glass from the beach, transported the pit back to the code office for further processing. The glass was disposed of in an approved trash receptacle. Placed a call to the company at 10:41 a.m. and got a response at 11:22 a.m. He was informed to report to the office after 1:30 p.m. to receive his citation and pick up his fire pit. Subject texted back to mail citation, and he would pick up his fire pit next week. And I've evidence presented as a copy of the citation, photographs of the fire pit on the beach, and also on the back is text messages I received from the owner.
All right.
Also have body cam footage if you need to see that.
Hold on to that for now. I don't know that I need to see it. We can, if you want to present it, I'll be glad to take it. I'll accept into evidence. Or let me do this. Are you Mr. Calthan? How do you pronounce that? Okay. Say that name again. Hey, make sure that mic's on. Is that? There you go.
Damien Gunn, G-U-N-N.
Okay, Damien Gunn.
Yes.
And you're here on behalf of Burks Beach Services? All right.
Correct.
Is it Calthon, C-A-W-T-H-O-N, the owner, Clay?
Yes, I was sent here
All right.
with his approval.
Understood. Just trying to make sure. And do you know Mr. Calthon's phone number?
Yeah, I have it handy.
Can you tell me what that number is?
Zach. 850-865-2623.
Okay, thank you, sir. All right. I believe Officer Guard gave you a copy of what he just gave me. Did
Correct.
you get a chance to look at it?
Yeah, everything looks accurate.
Okay. I'm going to accept this into evidence. Do you have any questions for Officer Guard at this time?
I don't. All
Okay.
of the events you seem to recount was true. So.
Right. Do you want him to show the video? I'm not going to require him to do it unless he wants to or you want him to.
No, that's fine.
Okay. Officer Guard, do you want to show the video? It's up to you. I don't necessarily
Unless you need it, sir.
I don't feel like I need it, but I also want to let you present your case the way you want to present your case. So you tell me.
I have it if you need it, but if you don't need to see it.
Okay. I don't think I do. I'm going to accept your packet into evidence. Mr. Gunn, at this time, I think I asked you, but I'll just confirm one last time. Did you have any questions for Officer Guard?
You said it was smoldering. It looks like it was covered in sand. Was there still smoke rising
Yes.
from the? Oh, okay.
And let me ask you this, Officer Guard. The requirement under the county's code is you're not supposed to leave anything, correct? You're just supposed
Correct.
to, like, when you come back out after the bonfire is over, whether it's smoldering, not smoldering, it's just supposed to be like fresh beach sand, correct? Okay, understood. Any questions, Mr. Gunn, based on my question to Officer Guard?
No, no more
Okay.
questions.
All right, do you have any, thank you, Officer Guard. You can grab a seat if you want.
Thank you.
Yeah, if, I mean,
You can either sit there or you can come up, but you're fine if you want to sit there.
okay, no, I was just gonna say that we're fine, of course, accepting any penalty, but we would prefer if we could serve the suspension immediately.
Do I issue the suspension today as well, or is it just the fine? I think you get points, right?
Okay.
And then the points, I mean, I don't know that I like pick the day, do I? I'm sorry? Yeah, y'all pick the day. Will y'all work with them on the day? Y'all do that, I guess, or, okay. So, did you hear that, Mr.
Yeah,
Gunn?
appreciate that.
Yeah. So that's not really what I do today. I know in another capacity, if you appeal, there's some talk about that. But I mean, I would just get with the county on that and they can maybe work with you. So the impact's maybe not that great for the business. All right.
Fair enough.
Anything else?
Nope.
All right,
That's
hold
it for
on
us.
real quick.
Okay.
All right, I'm going to close the evidence portion of this hearing based on the testimony and evidence presented. And I'm going to find that that although denied, I'm going to find there was a violation. In this instance, there's a $500 fine, there's a $50 administrative fee, and a $25 clerk processing fee for a total of $575. You'll have 30 days to pay that, or the company will have 30 days to pay that. It's not in this order, but there is some point system that's done through the county, which you're aware of. You'll have to deal with that with the county, but this is just the fine portion of it. All right, do you have any questions regarding the fine or the amount of time to pay?
No, I think this was like our first violation in the past 4 years, so I was wondering if there's any leniency with the fine itself.
Yeah, I mean, I don't have a ton, and you didn't really present anything to mitigate at this point. I mean, you just did tell me about the 4 years.
There's an absence of.
No, I understand. Yeah, unfortunately, I'm not going to do that today. So at this time, it's a $575, 30 days to pay, and I'm signing that order now, and you're going to get a copy of that. All right, good luck to you, sir.
Okay, thank you.
The next case is going to be La Dolce Vita, and it's also a failure to clean up after a bonfire.
Sorry, does this wrap up?
Yes, sir, you're free to go. Yeah, thank you, sir. All right. And you're here on behalf of La Dolce Vita? Okay. And we have Officer Stringfield. And what's your name, sir?
Bennett Carter.
Bennett Carter. All right, thank you, sir. And you grab a seat, and just like the last time, we'll allow the county to present, and then you can present anything you want me to. All right, thank you, sir. And Officer Stringfield handed me, and you gave a copy to Mr. Carter?
I did.
Okay, thank you, sir. All right, whenever you're ready.
On 10/4 at roughly 12 p.m. while on patrol, Officer Harris and I observed bonfire debris left on the beach at Scenic Gulf Regional Beach Access. Officer Harris and I attempted to contact La Dolce Vita and received no response. John from LDV eventually reached out to Officer Harris as I was in training at the time, and we informed him that we cleaned up the debris and will be mailing him a citation. And then the evidence provided, I've provided the citation plus 2 screenshots of the location of the bonfire itself with the vendor and the bonfire permit number. And then the pit plus remnants left onto the beach.
Okay. Was the pit where it's shown in the picture by the
No.
La Dolce Vita sign, or is that where someone from the county placed it?
No, sir, that is where it was placed when we found it,
Okay.
right outside the dunes. So it is at a different location.
And then,
But the remnants from the actual bonfire led to the pit. And I I also have body cam footage of that as well.
We'll hold that for this just for a second.
Yes, sir.
And then so the debris that's in the photographs, that matched up with the GPS location and this
Yes, sir.
permit? Okay. And I do have a copy of the citation, a screenshot of a GPS showing that that GPS location matches with TDC CE Bonfire Collection, La Dolce Vita, vendor number 76415, and then some photographs. Mr. Carter, do you have a copy of this packet?
I do.
Okay, do you have any questions, or do you have anything you want to mention about the packet before I accept it into evidence?
Oh, could we view that body cam footage? The reason being, my only argument here is location based, and the body cam footage will tell me what I need to know about
Okay.
that.
No, that's not a problem at all.
Specifically, you want me to put this so that way everybody can see it?
What I would do is why don't you show it to Mr. Carter?
Okay.
And then you can show it to me. If Mr. Carter wants me to look through something specifically that he wants to point to, and then we'll go from there.
Where I can see the background.
Yeah,
Yes.
the second one,
But I know where the pit is. I'm familiar with the tarp location. I'm just trying to see where the bonfire remnants are, if they're on 825 Scenic Gulf Drive's property, or if they're on the Walton County owned property in front of. That's what I was trying to see from this. Okay, so there's where your vehicle is. Kind of can see it at that angle.
All right. Do I need to, Mr. Carter, I'll be glad to look at it if you want to kind of walk me through, or did you see what you wanted to see?
So what I'm trying to see from this is, so my argument is that the remnants are on our private property for a different vending permit than the one used for the bonfire.
Okay.
From that video, I can't 100% tell that the remnants were on the public beach access. The only thing you can really see a location on is the pit itself on the private property where we hold a site-specific vending permit. So that was what I was getting at with the question.
Well, I don't mind looking at it, and you can walk me through it. I don't know that I'll see anything more than you saw. And I don't know where the property lines are, so I would leave you. You're gonna have to show me all that and kind of walk me through that
I gotcha.
process.
Yes, sir.
Do you want to do that first, and then I review the video maybe if needed, or do you want to just?
Sure.
Okay, go ahead. I'm sorry. Let's do this first. Officer Stringfield, do you have anything else you want to present this morning?
no, sir, that's all.
Okay. You have any other questions for Mr. Stringfield? Then I'll give you the floor. All right, go ahead.
Okay.
Mr. Carter. Yeah, why don't you, can you hand those up to me and I'll look at them while you narrate, or do you want to, and show it to Mr. Stringfield. Have you seen these, or Officer Stringfield? Okay. And if you'll do me a favor, can you step back to the mic? Because we record these, so I'm just trying to make sure we got somewhat of a decent record.
So the bonfire remnants, from what it appears to me, and I did walk down to the beach at a later time and could still see where there was an attempted cleanup, and I noticed where it was. So we hold a site-specific permit at 825 Scenic Gulf Drive, which is the property highlighted right there. That is where we certainly have a picture of the bonfire pit and the bucket and all of that in his evidence packet at that location. And it appeared to me that the bonfire remnants were also left on that beach. However, the bonfire took place at 917 Scenic Gulf Drive, which is the regional beach access. Correct. And so what I'm saying here is that this citation should not be for that bonfire. It should technically be a leave no trace assigned to that site-specific permit there because the bonfire took place at a different location. All we did was put away our things improperly on that private property.
Okay. The, do you mind, mark on here with an X where you think, or where you claim that you believe the bonfire was?
Based on his video.
Or where the remnants are, because hold on one second. We're only dealing with the remnants, right? Not the,
We're not dealing with the bonfire.
the bonfire pit itself, it's just the remnants that were left on the beach. Okay, that was my understanding. All right. Okay. And do you want to, or show that to Officer Stringfield. Officer Stringfield, Mr. Carter's testimony this morning is he believes, or he asserts, to the best of his ability, I guess, that he believes the bonfire was located about approximately where that X is, which would show it's on private property. We have your GPS. Have you looked at that? Do you know if there was another, another?
At that time, I do not believe there was. Yeah, so in that location, that would have been the old.
And that's marked not for, you don't even, do you even need a permit for private beach?
Yes, sir.
Okay. Was there 2 permits pulled for that same date and time, or around those same dates?
We would have to go back and look and see as we close out.
We're the only people who can pull permit to that location, and we did not have permit for that night at that location.
Okay, well, I'm looking here at the permit that shows 10/3/2025 at 7:51 PM. Would that have been the,
Yeah, well, so I'm not arguing that we did not hold a bonfire at the public beach access that night, and we did do the bonfire. I am arguing where the remnants were left and so our employees use our private property locations for storage. So like at that access, instead of us having to take everything from, say, the boardwalk, walking it, parking in the parking lot, all that, we use tarps on private property to
Right.
store things. So what I'm saying is he improperly stored and disposed of the bonfire, but not on the public property there, which affects one permit, whereas on the private property where he did dispose of things improperly affects a different permit. And so my argument is not that, it's visible to me that we did leave remnants and we did not put things away properly. However, we did not put the things properly away on our private property, not at the public beach access. And that's my argument here.
Understood. So, and that's what I'm trying to find out. I mean, it would seem as if you had a permit and the permit was located on public beach
We cleaned
access,
up on the public
but
beach.
you cleaned it up, but
Then then he proceeded to just throw it up at the dam
Correct.
and didn't care.
And I think the question for me is, do I have enough to say, regardless, because, moving it from here to over here, does that resolve the fact that you left?
Resolves one
remnants.
issue, but not the other, in
Right.
my opinion.
Yeah, I mean, I'm less concerned about the pit and the bucket, because I don't think that's what Officer Stringfield says we're here for this morning. It's more of the leftover wood, okay? And then if it's on this side of the property line, then you're in trouble, but if you're on this side of the property
We're in
line, you're
trouble
not
either
in
way.
trouble, right?
We're in trouble either way. What I was trying to say there is that I believe we're in trouble on one permit and not the other.
Okay.
Um,
Do you, what permit would you assert that would be in question versus the permit that's listed for?
So this citation was written to
Is that 76415?
our delivery beach permit, which is 27138. However, the site-specific permit for 825 Scenic Gulf Drive, where what appears to me the remnants and the pit and bucket and whatnot is at, is 00107.
Right. What do you have to say about that, Mr. Stringfield, or Officer Stringfield?
That specifically, I have nothing for that office, or for that, sir.
Okay, so do you assert that you believe you wrote it for the proper permit or not? Or,
I do, sir. I do believe that I wrote it for the proper location.
Yeah, I don't know that it's the location. I think he's arguing that they've got multiple
So
permits.
he wrote the citation correctly.
Okay.
I will say that. But I believe that we should have been cited for the remnants being on the private property, whether the bonfire took place there or not. Now, that's what I'm saying there.
So are you saying that the code number cited is incorrect?
The code number cited is correct. I'm saying so, it's back to what he was saying a minute with serving your suspension. That would be my delivery permit suspension. However, with where the where the remnants were located, that would suspend the permit for that property.
Okay.
And so, like I said, it is visible from the evidence that,
Okay.
but at a different location than what is being said on the permit.
All right.
I mean, on the citation, sorry, not the permit.
Yeah. And these citations are permit specific?
So, for this citation, how we do these is whenever we check the bonfires, check the permits at night, we stand over where the permit, like wherever the pit is, and we mark a pin, and then that in the mornings when we go back and check, depends on where we stop at to check for bonfire remnants.
And then if I come in to get a permit, or a vendor comes in, like La Dolce Vita comes in to get a permit, they have to designate
A location.
as a
for it.
vendor, right?
Yeah,
the
they have to
location.
designate a location for it.
Okay. All right. And so, Officer Stringfield, based on your review of the county's records, and I think Mr. Carter's saying, citation looks correct, code number or reference appears correct. You don't have any issues. You don't believe that this one permit or one vendor number or permit number versus another is applicable here?
I don't, sir, but again, I mean, we have the permit number. They have to put a location of where the where the bonfire is going to be.
Yeah. Okay.
And so you can look it up with the permit number right there of where the location is supposed to be.
Understood. I'm just trying to sort out I don't know all the ins and outs on how all this works necessarily for how you guys, geolocate and then assign, these bonfire permits. All right. Anything else, Mr. Carter? Any questions, based on my questions to, Officer Stringfield? Anything else?
Just to reiterate, kind of based on what you had said there, we did do a bonfire at that public beach access, and we did leave a mess not on the public beach access at a different location. So the permit for the bonfire was for our delivery permit. However, the mess was left where we hold a site-specific permit, and that's the only thing I'm saying there. We did mess up. We made a mess. I agree.
We understand.
So I'll leave it at that.
I mean, I don't know that I have any authority to say this suspension goes on that permit versus a different permit or something like that. So I'm going to deal with what I have in front of me this morning. I mean, Mr. Carter, if you want to get with the county and see if there's a way to, for them to assign it based on what you've testified this morning, I'll let you and the county try to work that out. I'm going to try to get everybody out of here. So anything else, Officer Stringfield? All right, anything else, Mr. Carter? All right, thank you both, gentlemen. I'm going to close the evidence portion of this hearing. Based on the testimony and evidence presented, I'm going to find that there is sufficient evidence to show that there had been a violation, specifically a violation of 22-54B1E of the Walton County Land Development Code. Based on that, there's a $500 fine, a $50 administrative fee, and a clerk processing fee of $25 for a total of $575. Mr. Carter, any issues with La Dolce Vita paying that within the next 30 days? All right, so you'll have 30 days to pay that, sir, or La Dolce Vita will have 30 days to pay that, and I'm signing the order, and you're going to get a copy from the clerk. All right, I appreciate your time, Mr. Carter, for coming up this morning. Officer Stringfield, thank you. I don't have anything else on my docket. Is there anything else that we need to address this morning before I close out? All right, not seeing anything, we adjourn. All right, good morning, everybody. My name is Hayward Dykes. I'm the special magistrate. I'll be hearing the matters this morning. If you have a cell phone, I'd ask that you either turn it off or put it on vibrate. And at this time, if you'll please stand, we're going to do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you all. If you can be seated. I've reviewed the minutes from last month and I've signed those. Are there any announcements regarding the agenda? All right. So number 12, CE 25-01184, that one's requested to be removed. Any others? Anything else? Okay. I'll go ahead and remove that at this point. Is anybody here for that? Do we know? Yeah, I mean, they're normally not, just making sure. Okay. All right, at this time, if you are here on a case or you plan to speak, that means provide testimony, or you believe you might want to present any evidence, photographs, anything like that, I'm going to ask that you please stand at this time and we'll swear everybody in at once. If you all raise your right hand, do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you all. You can grab a seat. All right, our first case this morning is going to be case number 25-01507. Property owners are listed as Pamela and Laudner, Laudenir, Lima. And the address is East Lamb Drive in Santa Rosa Beach, Florida. Is there anybody here for the Limas? Mr. and Miss Lima? Okay. All right. Not having anybody. Let me find this one. I know you put them up here. Where'd you put them? Huh? It says I know you put some up here. Which one is this one? This one? Oh, that one. Sorry. All right. All right, Officer Bennett, whenever you're ready.
For the record, I'm Code Compliance Officer Darnell Bennett. I am submitting my final summary report, presentation, and testimony in reference to case number CE-25-01507. The property is Lot 10 East Lamb Drive, Santa Rosa Beach, Florida, 32459. Parcel number is 25-2 South-2130-000-000. This property is in an unincorporated area of Walton County and therefore subject to the Land Development Code, Chapter 7, and county ordinances. The property owners are listed as Pamela and Laudner, Lima. The violation cited was 1.1300A development approvals. The initial complaint came in by email. An initial inspection was conducted on June 6, 2025, where I observed that at least a portion of the property had been cleared, including a 10-foot wide path for vehicles, but due to lack of development approvals from county's planning department, a stop work order was placed on the property. That same day, I spoke with the property owner, Ms. Pamela Lima, who I explained the nature of the complaint, the violation, and the stop work order. She mentioned that she would be submitting packets to planning soon for approvals and then to building department for permitting. A follow-up inspection was conducted on June 13th, 2025, at which time I posted the notice of violation to the property and was certified mailed. Follow-up inspections were additionally conducted on July 8th, July 22nd, August 12th, and October 24th to ensure that the stop work order was still in effect. On October 28th, 2025, I was informed that DEP was involved due to wetland impacts, and this was confirmed via email from the BPR reviewer, who forwarded me email chain correspondence between the complainant and DEP and the BPR reviewer. On November 25th, 2025, a notice of hearing was posted to the property, the courthouse, and certified mail. On this same day, I spoke with the property owner, and she informed me that due to personal matters in Tennessee, she would be unable to attend this hearing. She has requested, however, that she be granted the maximum time for the maximum time allowed for compliance. So as of today, despite all efforts, the property remains in violation of 1.1300A development approvals. The property owner has failed to bring the property into compliance within the allotted time. Notice was provided proper notice was provided by code. As of my most recent inspection of December 9th, 2025, the property remains in non-compliance. I ask that the magistrate file the property to be in violation.
All right. Do you want to introduce your,
Oh, yes, I would like to submit my packet into evidence.
all right, that'll be accepted. I see in the packet a copy of the notice to Pamela Laudner Lima at 219 Murden Way, a copy of a certified mail to the same address, addressed to the same owners. That notice for hearing is today at 10 a.m.
Yes, sir.
All right. What's the county's recommendation as far as the time period requested and fine?
After speaking with Rick from DEP, 90 days to bring the property into compliance or $100 per day fine, as well as a administrative fee of $73.
All right, thank you, sir. At this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusion of the law. I'll find that the property located or identified as Lot 10 East Lamb Drive in Santa Rosa Beach, Florida, parcel ID 25 2S 21 42 130 000 0100 is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented this morning, I find that there is sufficient evidence to show that a violation of 1.13.00A development approvals has been proven. Based on the county's recommendation, I'll provide that the property must be brought into compliance within 90 days. What's that date? All right. On or before March 10th of 2026. In the event the property is not brought into compliance on or before that date, there will be a $100 per day fine imposed. In addition to the fine, there's a $73 administrative fee. That'll need to be paid regardless of whether the property is brought into compliance. Property owner will need to pay that within 30 days. Officer Bennett, I have to tell you that you've got the wrong title on this order, so you'll need to go fix that. It says Deborah Christopher is the respondent. So I've marked it up. I'm not going to sign it. Do you have another one? Okay. Well, let me have that one then. It still says Deborah Christopher in the title. Yeah. All right. So if you will update that order and get that to me, I'll memorialize that. And we'll get that signed. All right. Is there anything else on this?
No, sir.
All right. Our next case is CE 2501546. Property owner is listed as Shannon Pringle.
Your Honor, if I may, number 5 on today's docket, case number CE 25-01427. Mr. Kaufman is here representing the respondent on that, and we have a stipulation to announce.
Okay. Is it going to be quick so we can take it out of order? All right. Sorry, Ms. Pringle, or Mr. Pringle. We're going to take this out of order real quick. All right. What's the stipulation and what do I need to hear?
And at this time, the agreement is the property owner is going to be admitting the violation that's before you for post-development order and post-permit changes. The agreement's gonna be for allowing 120 days for all construction to be completed to fix the issue that's in question. There's two pieces of materials that we would like to have placed in the record as exhibits, 1 and 2 for the stipulation that we're providing, because it's an enlargement of the typical amount of time. But with this, it's going to allow that not only the permit be granted, but the construction be done of, this was originally, it was a boardwalk. The boardwalk was taken out and gravel was placed in. So they have to get to potentially either the boardwalk going back in or an improved material being placed within that boardwalk area. So if I may approach, I can provide Your Honor this.
Yeah, that'd be great. All right. And I do have is this the county's packet, or was this something that you put
Yes, Your
together,
Honor.
Mr. Kaufman? Okay. Okay, so we're gonna introduce this into the record as well, along with what I was just handed that shows two items, one being the Dunlop Shipman dated August 21st, 2025. So this will be made part of the order as part of the stipulation, and then I've got an email from Melissa Ward this shows to Mr. Kaufman as well. This is dated December 9th. Also, when you get back to page 2, it has Stephen Schoen's email as well. So these two items, both parties agree will be part of the order. Okay. And then what are besides the 120 days, what else are we agreeing to this morning?
The administrative fee, as well as the fine after 120 days. If work is not completed in that time period, then it would be at 50 is the
Okay.
And we can provide Your Honor with a written order if you would like by next
Got one
Friday.
up here, unless y'all want to put something else together.
I would like to see it.
Sure. Yeah, it's our standard order with blanks that I usually fill in as we go through it. So you'll see in the first, underneath the order, the first full sentence, respondent is to correct and then there's a blank, so we would put the date, the $250 per day shall be imposed after that. And there's the second one would be the admin fee, and then usually that's paid within 30 days unless there's some agreement between the property owner and the county for lesser time or more time. And then I would just make a note under other on page 2 at the top, which would say that these two attachments would be part of it. Would there be anything else that would need to be special or specific for this particular matter?
Making sure that we're clear that it's for the repairs to be completed within that 120 days.
Okay, I can either put that in the order if that's not more fully flushed out in these attachments.
Yes, we would request you include that in the order. The original violation notice, one of the options was obtain a development order for what's done,
Well, like I said, I'm fine if you guys want to take that, wordsmith it to where both parties are good, and then bring that as a fully formed document to me, and then, based on your representations, assuming everybody's good with it, then I'll sign that. All right, so let's just, I'll hand this back to you then, if you want that. I'll just make the following findings based on the representations. So we can go ahead and kind of put a pin in this for today's hearing. So this is case number 2501427. Property owners listed as Watersound Beach Community Association. Based on the representations by Walton County and the property owner's representative, Mr. Kaufman, it's my understanding that the parties have agreed to 120 days to bring the property into compliance, and the violations alleged or admitted to at this time by the property owner, and that is that 113, 1.13? Okay, so 1.13.06 of the Walton County Land Development Code, property owners admitting that this morning through their representative, based on the following being approved by the county or by myself: $250 fine, or let me do it this way, 120 days. So when would that need to be? Okay, so on or before April 9th, 2026, property will need to be brought into compliance. That can either be done by getting a permit or, I guess, remediating the walkway or boardwalk, whatever that is. What is that?
So, well, it's going to be a stabilized path of a crushed stone.
Okay. And I did accept into evidence, or the record, the county's packet. Is there anything else that you want from the owner? Okay. Okay. So then we did that, and then the admin fee was $73?
Right.
All right, so admin fee is $73. Do we need extra time to pay that, or can that be done in 30 days? Okay, so that'll be 30 days from today, or from the date I signed the order, since I'm not signing the order today. There's also gonna be 2 attachments, that the parties will agree to. I mean, if y'all wanna make that one attachment, however y'all wanna do, we'll attach that to the record, and then you'll put in the language that they can either get the permit for what's out there now, or they can remediate or do whatever, right?
The goal is to make sure that within 120 days that whatever construction needs to be done to that location is completed.
Okay, and that's agreeable by the property owner, Mr. Kaufman? Okay, all right, I'll be on the lookout for that order once you guys exchange and approve that, and I'll get that signed as soon as I can, all right?
If we can just put a date, maybe next Friday, to have the order.
Okay, yeah, if the parties will just agree to get me that order, get whatever red lines, y'all have done this before, back and forth, and then I'll be on the lookout on or before next week, Friday.
The 19th, Your Honor.
Right? So let's say by noon on the 19th. Okay, midday. That should give y'all plenty of time, I would hope. All right, so on or before the 19th, December 19th, by noon, I should have that order, if not before. All right? And y'all have my email, so you can just send it that way. All right, thank you both.
Thank you.
All right.
That's all I have, if I may be
Yeah,
excused.
yes, ma'am. Have a good day. All right, getting back on track, maybe a Mr. or Mr. Shannon Pringle. Is anybody here for, okay, great. And then the address is 13935 State Highway 20 West, Niceville, Florida. And are you Miss Pringle? Okay, great. So Miss Pringle, what we're gonna do is let the county present, and then you'll have an opportunity to question the officer, present any evidence or testimony after they're done. Okay? So, all right, let me find this. All right, whenever you're ready.
Testing. There we
There
go.
you go.
I'm Code Compliance Officer Greg Forehand. For the record, I'm submitting my final report summary, presentation, and testimony in reference to case number 2501546. The property is in the unincorporated area of Walton County and subject to Land Development Code per Florida Statute Chapter 162. Location parcel number is 28-1 Sierra-21-41021-003-0310, also known as 13935 State Highway 20 West, Niceville, Florida, 32578, belonging to Miss Shannon Pringle. The violations originally listed were 50709C for junk and debris, which was corrected. 70203 dilapidated structure, 50709 B Bravo for duty and maintenance to private property. The complaint was received on 6/2/2025 with initial inspection conducted on 6/23/25 with inclusion of access to the complainant's property to take photos. Also received photos from the complainant that were requested to be entered for consideration on 6/24, showing under Exhibit 3. On 6/30/2025, the notice of violation was prepared and placed in certified mail, along with a posting being made to the property on 7/1/2025. There wasn't a contact attempt made at the time of posting due to inclement weather on that day. On 7/17/2025, I had not received any type of contact from the owner and returned to follow up, finding the debris pile listed in the notice had been removed, along with landscaping completed to the yard, but again had no direct contact made during the inspection. Throughout the follow-up investigations, I attempted contact at the door, leaving an extra courtesy hanger, and by phone through both text and calls, and having the owner's number from some prior interaction with Ms. Pringle. On 9/28/25, I placed a notice of hearing in certified mail with Code Compliance Supervisor Hicks, posting the notice on the property on 10/13/25 per my request, being she was going to be in that area. She also advised that no contact was made while posting to the property. The notice of hearing mailing returned undelivered on 11/10/25, and with the posting of the notice of hearing made at the courthouse annex on 11/24. Follow-ups have continued up until yesterday, 12/9/25, for the pre-hearing inspection, which is showing in Exhibit 6. There has been some cleanup and maintenance to the primary structure and property, but no significant change to the appearance of the accessory structure that's in question. There was an email interaction from Ms. Pringle yesterday on 12/9 requesting a continuance, but with the time that has elapsed and preparations is put forth, the request was denied, and I would like to submit my packet into evidence.
Ms. Pringle, did you get a copy of the county's packet?
I did today.
Okay. And do you have any questions or anything before I look to accept this into evidence? Okay, great. Do you have any questions at this point from Officer Forehand regarding his the case or the presentation or what he's testified to this morning? Can you turn that?
Will the code enforcement officer be providing testimony, or is it?
That was his testimony. So if you want to ask him specific questions, show him photographs, this is your opportunity. But yeah, that was basically his testimony or presentation of the case.
Thank you. When was the most recent formal notice issued to me?
Notice of hearing? Well, the hearing was placed in the mail on 9/28, and it was posted on the property at on 10/13 by the mailbox, and after a follow-up investigation or inspection after that, the posting had been removed. So I assumed it had been required, and the mailing one did return on 11/10 as not received or either not signed for on the certified mail.
Yeah, and Ms. Pringle, there are some pictures of this, Exhibit 5 in that packet he provided.
I'm still trying to review the packet. It was.
I understand. Yeah, I know there's a decent amount of stuff in there, but I just wanted to point that out to you. There is a picture of the certified mail, a picture of the posting, a picture of the notice. I have a copy of that notice in my packet as well. I just point that out. I didn't mean to interrupt you necessarily. If you have additional questions, go ahead.
Was there a formal notice of violation, and is that the one included in the packet dated August 30th, 2025.
Yes, there was one mailed that did return unsigned, and there was one also posted at the property on the 7/1/25.
And was there any written or verbal warning provided before issuing the notice of violation?
No, the violation consists of the of what needs to be rectified or corrected.
Why was I not notified of any issues between April of 2024 and November of 2025?
I did not get a complaint again until that time, when we closed the prior case for the roof permit.
And in April 2024, after I had cleaned the porch, removed the debris, patched the roof, did you tell me that no further action was required?
At that given time, the only thing that was required, which you did obtain, was the roofing permit for the correction, but it wasn't followed through with after and expired before a new roof was placed on the accessory structure.
Did you not send a text message stating or thanking me for the work that had been done as far as the debris pile? And let me just find that now.
Yes, well, that's why I did remove that violation for the junk and debris. That's no longer a part of this packet.
And
It
the
was-
porch.
It was listed as corrected.
And the porch was also mentioned in your prior text messages too,
Yeah,
correct?
and which in the final inspection yesterday, I did note and see that some correction had been made with it being cleaned up. But the duty of maintenance still pertains to that structure, in case you can get an evaluation or allow permits to repair it. So that will require a duty of maintenance on that portion with the accessory structure.
Okay, and by accessory structure, you're referring to the garage, correct?
Yes, ma'am, the house that's been there, the one that's along the property line.
Okay. And you said they were, I'm sorry, you said that you did notice that they were corrected, that was cleaned.
Yes, ma'am.
Okay.
It appeared the rear decking and around the pool area appeared to have been cleaned up and pressure washed, along with the debris pile, which I have photos
Okay.
in that in exhibit and and those portions
Okay.
of the
And-
corrections that have been made at this point.
And you correctly stated that the roof had not been replaced, but were you aware that it had been repaired?
I don't have access to get that out to see if it has been repaired, but from the observation made yesterday to the southern portion of it, it appears it still could be potentially in disrepair. It doesn't go out to where it looks like the original beams would be across on the front of the porch. And there's other existing holes and damages visible from underneath on the eaves of it.
But not on the roof itself?
Not on the very top of the roof, no ma'am.
And were you able to observe support structures for the porch on the accessory structure?
I did observe the supports there, but I don't know if they're to the spec that the building department would approve as to be safe. I can't determine that.
And do you know on or about when these corrections were made, whether it was prior to this secondary complaint filed by the neighbor?
I wouldn't know an exact date, but I did see that some efforts have been made to stabilize that the deck and front area.
Okay, but, and I mentioned April 2024 because we had a previous conversation back last year, over a year and a half ago, correct?
Mm-hmm.
Okay, and in April 2024, the neighbor had called you complaining about the same things, correct?
Pretty much. The
Right.
concerns of the structure, yes.
Okay, and at that time, we spoke quite a bit. In fact, I have a 30-page packet of text messages between you and I discussing the situation and the repairs that had been made. And at that time, the only thing done was the roof, or to be done left was the roof on the garage, correct?
Mm-hmm.
Okay, and you were, because you've been unable to reach me, you were unable to inspect whether the holes had been repaired in the roof, correct?
Yes, ma'am.
Okay. And then I believe there was a date in November of 2025 that you had visited my property, correct?
Yeah. Yeah, I've done a few follow-ups out there and attempts at contact.
And I think I even noted in here about the cameras, you observed the cameras.
Yeah. Which is a presumption, being there's cameras there. I don't know if they're active or not, but presumption would be, there's possible footage of me being on the property or at your entry there.
And just back to the complaint itself, this most recent complaint, who was it initiated by?
The information is in the packet, but I believe it's gonna be the same number from the past.
Okay. And has the neighbor made other prior complaints that were found not to be violations or not to be code enforcement matters?
Up till the interaction we had with the prior roof, neither the roofing permit and repair, I'm not familiar with anything other than what I've handled.
If I, or strike that, did the neighbor ever complain about a fence or property line issue with you?
Oh, yes, there's been concerns due to the property line, which I told them both of you, that's a civil issue. That's anything to do with us. I mean, and I'm understanding that that structure is non-conforming, was built in the 70s, with the property line setbacks being different today. So,
Did the neighbor relate to you what his desired outcome of these complaints would be?
well, I'm sure he has stated he would like to see the building down, or at least repaired to be safe, so they don't have any concerns of it falling over onto their property.
That's all the questions.
All right. You can grab a seat, and then whatever testimony evidence, Ms. Pringle, you want me to consider at this time?
Will the neighbor be testifying?
I don't know. Did y'all ask the neighbor to show up? Yeah, I mean, if he wants to testify, that's up to him. But he doesn't have to testify. That's up to you. Yeah, come on up. Yes, sir. You'll have to state your name for the record, and I'll just want to confirm that you were sworn in earlier.
Yes,
Okay, thank you, sir. What's your name?
Dennis Hargrave.
All right, Mr. Hargrave. I'm gonna allow Ms. Pringle just to ask you, well, let me do this. Does the county have any questions for Mr. Hargrave? Okay. Well, hold on. If you're gonna come up and say, I need you to do it at the microphone.
The only thing I had was being he did send photos, if he needed to make statements towards that he did take those photos.
The photos that are in the packet?
Yes,
that-
sir.
Okay. Well, I'll have, Mr. Hargrave do you want to ask him about which photos he took or sent in? Or is it all the photos?
Pretty much, if you want to state that you did send me the photos after my initial inspection, where,
I did.
because he did suggest that I could get to a higher elevation on his property, and I said I wouldn't want that liability. And so the next day, did you send me photos next day where you either took a ladder or gained access from your property or
Yeah.
your rooftop to send me those photos of them?
Can we identify which, I mean, there's several photos in here. Some are from a higher elevation, obviously.
Yeah, the ones from higher elevation under exhibit, I think it's 3.
Yeah, this is this 4-pack of photos on
Yeah.
one page.
Yeah,
Exhibit
that's
3, dated
Once he sent, yes, sir.
6/24/25, caption south roof damage. Those were taken by you, Mr. Hargrave?
Yes, sir.
All right. and you submitted those to the, Walton County, code compliance?
Yes.
Okay, all right. Thank you, sir. Anything else from the county? Okay, then, Mr. Hargrave, I'm gonna allow, Ms. Pringle to go ahead and ask you some questions. But I'm gonna let you go ahead and testify. What do you wanna, I mean, you voluntarily stood up, so it's up to you, but what do you want me to hear? And then I'm gonna allow Ms. Pringle to ask you a couple questions.
It's a concern. I live next door, and I like Miss Pringle, so there's no beef with me with her. She had a tree on the back of her property. It was a big hickory tree, and I had a tree cut down on my property that was actually 10.5 feet diameter, which wound up being 2 trees that had grown together. But anyway, the bottom line is her tree was an issue, and we knew it, and I had cut down 2 trees, and I let her know that, these guys, they can probably do you a good deal, because we knew the tree was going to be an issue. Nothing was done at that time.
So, hold on, Mr. Hargrave. Is this relevant to what we're dealing with this morning?
Yes, sir.
Okay.
Yes, sir. It has to do with this structure. There's a stump in front of this structure that a tree fell into it with a storm, and then that damaged the roof. And so the tree was cut down after, I don't know, a year or whatever. But the damage wasn't done, and Miss Pringle told me that the insurance company was supposed to do it, was supposed to come back and fix it, and that it was held up in court, that she was, couldn't do anything because of that. So 2 years went by, I guess, and the condition's still the same, and at some point, an issue was made of complaint. And so she did have, get some, I guess, estimates, but nothing ever happened. And then the time's gone by, and there was another complaint. And being a good neighbor, I tried to give allowance time-wise. So we're basically 4 or 5 years down the road on this. And so here we are again. And so I would show you this picture here that's on my phone, if it's okay to approach you.
Well,
This was taken yesterday.
If there's no way for us to put it in the record,
Okay.
It's hard for me to, I don't want to take your phone, obviously.
But anyway, the bottom line is the roof is still not repaired.
Okay.
And the door on the front is not secured well.
We're talking about the door
Yes,
on the
sir.
upper,
Yes.
on the second floor?
Matter of fact, the one that, that's showing it, it has a bungee cord type thing holding the door. The concern, the biggest concern is because of hurricanes. I had 2 structures in homes in Panama City torn up, and we've been lucky so far. And I've let Shannon know that this is a potential danger. That front can blow the door open, the roof can get blown off, and it depends on how strong the storm is. It can tear the thing down, and it can fall over and damage our house. But anyway, so I'm wanting the whole thing to be. And she had mentioned that she would like to get rid of it, but I don't know why. She can't get rid of it, but probably financial concerns. But the bottom line is the structure. Also, my house that I remodeled, it had severe termite damage, and this is right there. And I don't know if there's ever been any kind of treatment for termites. That would also undermine the safety of the structure itself. It's had constant leakage coming down the walls, and so whether it has structural integrity is really a question in my mind.
Understood. All right. Let me go ahead and have Ms. Pringle. Ms. Pringle, do you have any specific questions for Mr. Hargrave?
I do, sir, but can I get one clarification? I believe Mr. Hargrave said he took the pictures in Exhibit 1.
Oh, he said Exhibit 3.
Oh, Exhibit 3.
They're they're from a higher elevation. You can
It's
see
from
the
my roof next door.
You can see the roof structure on your property, Ms. Pringle, as well as there's two photographs of the door. One's a little further back, one's a close-up.
And Mr.
Hargrave?
Forehand,
Mis-
Mr. Forehand took exhibit 1 and 2, is that? Oh, thank you.
Yes.
Thank you.
All right, so Ms. Pringle, like I said, I'll give you an opportunity to ask Mr. Hargrave some questions. We're not gonna take too long, because I want to hear your testimony, so we can kind of get this towards a resolution, so we can move on with the rest of the cases this morning. But go ahead and ask Mr. Hargrave any particular questions you may have at this time. And again, base it off of his testimony. We're not gonna talk about prior things unless they're germane and relevant to what we're dealing with this morning.
You've told me that you wanted the garage gone for personal reasons and not safety, is that true?
No, I always said it was an issue as far as the structure itself was
told me-
messed up. Also, I did say that it was built on the property line, which isn't, normal. The background of that is simply that the people who lived there, they were the Sallies. And the
Well,
Sallies.
Mr. Hargrave, I'm sorry. Just let's, so we
Okay.
can kind of move this along. Let Ms. Pringle ask a question, you answer that question, and then we're going to try to move along.
Okay. So I guess the simplest way to say it is that the structure itself is unsightly. It has stuff hanging all over it. There's still stuff from the leak of the roof, 2 years ago or whatever. And it's just not a good place for it to be. And I wish it was gone personally, but it's just a bad, I wish I could inspect it or someone else could inspect it, because I feel that it's going to be a dangerous thing in the future.
Was the issue 2 years ago or 4 or 5 years ago? Because earlier you said it was, you started 4 or 5 years ago, and you just said 2 years.
The roof issue happened when the tree hit your building and messed up the front of it.
Have you expressed to me frustration that the garage is still standing?
Say it again?
Have you expressed to me your frustration that the garage is still there, that it's still standing?
I've had trouble getting contact with you, knocking on your door and different things, and you never being available because I guess your work schedule. You say you work during the night, you're never awake during the day. But that issue is going on. It hasn't been resolved, and so then us talking about the property line, we're trying to figure out our property line exactly where it is, and we have 4 surveys, and we're trying to.
And you said you don't like that the building is on the property line, and that's one reason why you'd like it removed. But you do understand that if the building were removed, it could not go back because it's grandfathered in as it is.
But I'm not trying to get the building removed as a legal matter because I believe it is grandfathered in.
Have you called code enforcement over the fence that was installed on the north side of the building?
Yes, I said that the fence was put in an improper place, that the marker, the concrete with the pin in it for survey purposes, you had gone beyond that, as I warned you when you were doing it.
Well, hold on. Ms. Pringle, Mr. Hargrave, we're not going to litigate a civil matter about where a fence is, so don't ask him any more questions about a fence. You ask him about the structure, you ask him about his photographs,
Okay.
and then we're going to move on, all right? So,
Do
go ahead.
you frequently observe or monitor my property from yours?
Question?
Do you frequently observe or monitor my property from yours?
Sure.
Okay. Do you frequently come into my yard over the property line?
No. No, I'm.
Did you
Detention.
contact code enforcement in June of 2025?
Say that again.
Did you contact code enforcement in June of 2025?
I'm not sure the date. My wife called, whatever date that was. It should be in here.
Do you know what issues were raised at that time?
Issues are always there. The place needs to be repaired, and it needs to be fixed up so it doesn't look like, you know, a junk house.
So you don't like the appearance of the building?
No, I do not.
It has nothing to do with safety?
Oh, it has everything to do with you getting the place looking so it.
Have you spoken to me directly before to resolve concerns before calling code enforcement?
Ms. Pringle, he's already answered that question. He said he's tried to reach you, knocked on your door, has had trouble getting in touch with you. What other questions do you have for Mr. Hargrave?
That's all.
All right, thank you, ma'am. Any other questions from the county for Mr. Hargrave based on that testimony? All right, thank you, sir. All right, Ms. Pringle, at this time, it's your opportunity to present evidence or testimony.
I would like to present photographs as well as text messages. I have
All right.
copies for you, but not for Mr. Hargrave. I approach.
Yep. I'm gonna mark this as Respondents Composite Exhibit 1. I've been handed by Ms. Pringle several photographs. These include photographs, what appears to be her property, some photos from her foyer that I believe have Officer Forehand and maybe others from Walton County in those photographs. Appears to be the front of the property. I also have several pages of text messages that have been printed up. I'm not gonna read all those right this second. I'll allow Ms. Pringle to present. Is there anything else, Ms. Pringle? Is it that this is everything that you wanted? So I'm gonna,
Yes.
County, do you have any questions? I'm gonna accept this into evidence, or do you have any objections?
The text messages will involve prior
All right, yeah, we're not here to deal with the prior case from last year, so we're gonna just, understood, but I'll go ahead and accept them regardless. And if she begins to speak about something that's from a prior case, I'll ask that you identify that and let me know that was from prior, because I don't see dates on the text, but I do see, you know, timestamps. Let me take that back. I do see some dates from April of 2024, as well as timestamps on some of these texts, but on some others, I do not see those same date or timestamps. But with all that being said, Ms. Pringle, we're going to accept all this in as Respondents Exhibit 1, and go ahead.
Sir, the reason I had mentioned the 2024 was because the complaint itself states that it's a recurrent violation of the April 2024. That's why it's referenced back to April 2024. But I want to emphasize that I have complied with any required actions that have been given to me. I was told that nothing further was needed. There was a pile of debris out front that was cleaned up in 2024 that had not been previously picked up by sanitation. So it was picked up by myself and had taken it away. Now we have garbage bins that the county actually picks up from their bins, so you don't leave bags on the curb. But after that point, I received no warnings, notices. What was alleged to be black mold on the back porch was in fact dirt, as shown by the pictures I have provided, as well as from potted plants, roof runoff, AC runoff. If it rains, it's washed off. So you can see that there is no black mold or algae growth on the rear decking. It's just whenever it rains, that's gonna happen. So The only issue remaining then, as shown in the text messages, was the roof. I did as instructed and got a permit to replace the roof. The gentleman that was going to replace the roof, after speaking with code, then came back and said it was going to be double to replace it, so I had to repair it. Repairing it did not require the permit because of the percentage. So that had been done. There's photographs in there that I would dispute his photographs as far as timelines, because the ones provided by Mr. Hargrave are definitely older ones. You can see in the more recent ones, door is shut and it's a lot better than those.
So do you have photographs? Did you provide me photographs showing the roof repair, or are you claiming that the photographs that Mr. Hargrave took that are in Exhibit 3 of the county's report is the current condition of the roof?
No, I am stating that those are old ones.
All right. Well, those are, yeah, it looks like that was, let me see. Those are dated photos of structure on property line 6/24/25. So that's not the current condition of the roof.
No, sir.
Okay. And where do you have to show me the current condition of the roof?
I wasn't provided with this until this morning, so I did
That's
not
fine,
have
ma'am.
time to prepare.
Ms. Pringle, you don't need the county to come out and take pictures of your roof if it's been repaired. You take those pictures, you bring those in today and say, here, Mr. Dykes, these were photos I took yesterday. My roof has been repaired. Do you have those for me today?
I do not.
Okay.
I did not know what this was about. I assumed it was from 2024.
No, ma'am. It's not about 2024.
And I did not know that. That's why I asked yesterday for a continuance.
Okay. I'm sorry. Go ahead with the rest of your testimony.
So these repeated complaints are coming from a single neighbor who has routinely reported non-violations for personal reasons, which places me in a rather difficult and unfair position. I'm not refusing to maintain my property. I just cannot correct a problem that I'm not notified exists. And for these reasons, I request that the board or Your Honor dismiss the violation, or alternatively allow me reasonable time to address whatever issues there may be once the proper notice was received, which I was provided with 10 minutes prior to this hearing.
All right. Ms. Officer Forehand, do you have any questions for Ms. Pringle? Okay. Please, I've got a question for the county. So as we sit here today, what would Ms. Pringle have to do to bring her property into compliance? You said 5.07.09C, exterior storage, junk or debris.
Well, that one was removed.
That's been removed.
Yes, sir.
So what I have before me this morning is alleged violations of 7.02.03, dilapidated structure. You have as corrective action, at least in the report, obtain a permit to allow for proper repairs and bringing the structure back to a safe, usable condition, or a demolition permit to remove from the property. And then the other alleged violation is 5.07.09 sub B, which is different from the one that's been removed. And that's cleaning of what appears to be black mold, algae growth on rear decking. And Ms. Pringles has testified she has done that.
And yesterday's, my observation yesterday, it did appear that the rear deck and pool area had been significantly cleaned. That could also be removed at your discretion.
So then,
I wanted it to be there as a prior observation to remain in case it comes back around as not being maintained. I mean, when it was left on there as to be seen as it had been.
well, we have a procedure where if the county can prove that there was a violation, but as of the date of the hearing, which is today, the violation has been cured.
Yeah.
We
Yes, sir.
can designate that as a
Correction.
correction, but allow for the county the expedited procedure under the state law, which allows for quicker notices and as a repeat violator, basically.
Yes, sir.
So that's the only reason is that your testimony? The county
Yes,
left
sir.
that
That
on
is
for
my-
5.07.09B, But that's been resolved as we sit here today, in your opinion.
From the view I could get and the photos I could get, it did look like it was in much better condition yesterday.
Okay, my question was, has it been resolved?
Yes,
Okay,
at this
so
moment.
For the county's
Sorry.
testimony, that matter's been resolved. We'll address that after we get done with the facts portion. So the only thing remaining, based on the testimony and evidence presented this morning, is 7.02.03 dilapidated structure. And are the corrective actions still the same that are listed in the report?
Yes, sir, I feel they are.
Okay, and those two things, Ms. Pringle, is the county's evidence and testimony is today is either you obtain a permit and make the repairs, or you seek demolition permit to remove the structure from the property. So it's kind of, I guess your choice, pick your own adventure type of deal. But if you've said that you've repaired the roof, then it may just be a situation where you need to have the county come out and verify that the repairs were done and they were done properly.
Or would you allow a set time to submit those photos for you?
Well, no, we're going to deal with this today. I'm not going to keep this hearing open. So what's going to happen is there's going to be a ruling today. And if you prove that it would be like, just as an example, like if you had to remove some trash from your yard or garbage, you don't need to come back to me and say, hey, here's the pictures, I've removed it. Show that to the county. County says, yep, you've removed it. Then you're done, right? I don't need to look at pictures just to say, yeah, I agree that the trash has been removed. So yeah, I mean, you will have some time. I'm going to give you some time to submit whatever you want to submit and seek whatever permits if you decide to seek any permits. But that will be something that you can decide to do on your own. All right. Is there any other testimony or evidence that I need to hear from the county on this matter?
No, sir.
Okay. Ms. Pringle, any other testimony or evidence you want me to consider this morning? All right, thank you both. All right, at this time, I'm going to close the evidence portion of this hearing. I'm going to make the following findings of fact and conclusions of law. I'll find that the property located at 13935 State Highway 20 West in Niceville, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find there is sufficient evidence to find that there are two things. One, that there's sufficient evidence to show a violation of 7.02.03 dilapidated structure as it relates to the roof. I think the photographs do show the roof structure on that garage or accessory structure that Ms. Pringle owns on her property to be in a dilapidated state. She's testified she's made those corrections. She'll need to get with the county to show that those repairs have been made and they've been made sufficiently. But I will find that is a violation as we sit here this morning. How much time is the county requesting to bring that piece into compliance?
Well, with the time that's lapsed, I was just going to request 33 days due to my schedule. And that'd be 1/12 of 26. If she feels she may need more time, into your discretion.
Well, Ms. Pringle's testified that she's already made those repairs.
Okay.
Ms. Pringle, do you think 33 days would give you enough time to get that proof to the county?
More than enough.
Okay, so then we'll do that. We'll do 33 days. In the event the property's not brought into compliance, what's the county requesting as a fine?
150
Okay.
daily.
Ms. Pringle, do you have any comments on that?
No.
All right. Based on no objection by Ms. Pringle, we will, and the county's recommendation, I will order that the property needs to be brought into compliance on or before January 12th, 2026. In the event the property is not in compliance on or before that date, a $150 per day fine will be imposed. There's also the issue of an administrative fee.
Which is $73, sir.
All right, I see that. I'm going to order a $73 administrative fee be paid, Ms. Pringle. That'll need to be paid regardless of whether or not your property is brought into compliance, and you'll have 30 days to pay that. Now, the second part of this is 5.09.09B, duty of maintenance to private property. So based on the testimony and evidence presented by the county this morning, as well as Ms. Pringle, I will find that there was previously a violation of 5.07.09B as it relates to the back decking. But as the testimony was from the county, that matter has been resolved. So that violation for that particular section of the code has been resolved. However, in the future, if there's a similar offense, and it's got to be under that section of the code, if it's another subsection, then they got to do it a different way. But if it's for that, same nature as cited in this case, will be considered a repeat offense and subject to fines as such. Still get a hearing, still have to come here, but it's just an expedited process for the county. You understand that, Ms. Pringle? Okay. So no violation, no fines on that. Okay. All right. Did I miss anything from the county side?
No, sir.
All right. Ms. Pringle, do you understand my order as I've recited this morning? All right. I appreciate, Ms. Pringle, you taking time out of your day. We've accepted into evidence. I'm going to put this over here so it's made part of the record. Ms. Pringle's packet of information. And Ms. Pringle, you'll get a copy of this order sent to you, and I wish you luck, all right? And your case is over. All right, our next case is 25-01531. Property owner is listed as Ashley Lucius.
Yes, sir.
All right, Mr. Lucius, is that proper pronunciation?
Yes, sir.
Okay, great. Mr. Lucius, you've had an opportunity to see kind of how we're going to go ahead and, I know you've been waiting a while. We're going to try to get you in and out as best we can. So, you got my packet up here. All right, I think I've got it. This looks like it was Officer, is it
Baza.
Baza's?
Yes,
Okay,
sir.
you're presenting on behalf of Officer Baza this morning?
Yes, sir.
All right, whenever you're ready.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony in regards to case 25-01531. The property is located at 971 Musset Bayou Road, Santa Rosa Beach, Florida 32459. Parcel number 28-2 South-20-33226-000-0010. Property owner is Ashley Lucius.
Yes.
Lucius. The property is in an unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 1.13.06 post-permit changes. On June 16th of 2025, our office received a complaint stating installing a pool and deck without permits and within the wetland setback. On 6/16 of 2025, Code Compliance Officer Baza conducted an initial inspection with the assistance of CCO Forehand. The property owner allowed access to his backyard where CCO Baza gathered photos of the pool, patio, and turf. CCO Baza informed him that the additions may require a plan review from the planning department. On June 24th of 2025, a notice of violation was given as prescribed by code. On August 4th of 2025, CCO Baza received an email from Brad Bond after he conducted a site visit stating that based on the survey and the site visit, that there were several site improvements made in the wetland buffer and outside the platted lot lines. All improvements off lot and within the 25-foot wetland buffer need to be removed and the buffer restored. Brad also stated that the pavers on the northern boundary will need to be removed out of the landscape buffer. On October 12th of 2025, a notice of hearing was given as prescribed by code. In the case detailed report, it shows that CCO Baza has been in contact with the property owner throughout this process. On November 18th of 2025, CCO Baza found that the property owner had applied for a pre-application meeting for a variance and it was scheduled to be held on November 26th of 2025, but due to the holiday, it was rescheduled for December 5th of 2025. I believe it was held on the 8th, which was yesterday. That pre-application meeting was held. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
Okay. Mr. Lucius, did you get a copy of the packet? Do you have any questions before I accept this into evidence?
Yes, sir, I did get the copy of the packet. Just as a correction, it was held on the 5th for our
was.
pre-variance.
Okay. All right. Anything else? Any other comments on that? I'm gonna go ahead and accept this into evidence.
Yes, sir, just a few quick comments, and I've spoken to you earlier as well.
Well, hold on
so-
one second. Do you have any questions for her?
I do not.
I know she wasn't the officer that did a lot of it, but he's not here with us. But if you have any questions, this would be the time to ask those of Officer Neenan.
I do not have a
Okay,
question.
I'll let her take a seat and then go ahead.
Okay, so just as a quick matter, we are trying to get this issue resolved with planning and development through pre-variance meeting. Obviously, we would need a substantial amount of time to go through that process on both issues because it does require environmental study and survey. So some of these issues obviously were brought to our attention. We were given permission to use that common area that's cited outside of the lines there by the original developer of the neighborhood. The front lots 1 through 5 were given that permission to use the common area. And if you look at the current AIGS map, that is no longer considered a wetland.
Okay.
I do have copies of that here as well.
Well, let me ask this. So this is, sounds like you're trying to get this matter resolved in some form or fashion administratively through the county's process. Are you looking to continue to go? I mean, I can take all that in, but if you're trying to get it and you get a permit or you get approval, however that may work, then this will essentially go away, for lack of a better term. But is that all you're asking for today? Is just some time to kind of let that process run through?
Yes, sir.
Okay. How much time do we think is going to be needed for the? Because
On Friday, yes.
When I talked to Bridget Clements in the planning department yesterday about this case, she did say that there was going to be some complications as far as the developer gave them permission and then the HOA feels differently. But that is a civil issue. I know he had mentioned that. As far as the variance process goes, she did state that, hold on, sorry. She discussed that, with him the plan moving forward. She responded, stating that the property owner will be applying for the variance for the landscape buffer and the rear encroachments. She said that I believe the next variance meeting is toward the end of January 22nd possibly, but it depends on his ability to be able to provide those documents moving forward to be able to get in front of the variance board.
well, the variance board's only going to be able to deal with things that are on his property. They're not going to.
Right. I just wanted to
ability-
clarify what he was talking
Yeah.
about as far as the ones
Understood.
that are not on his property.
And Mr. Lucius, you may or may not know this. I mean, coincidentally, I'd act as the attorney for that board, so I'd give them legal advice if they need it. But they'll only be able to deal with matters involving your property. They're not going to deal with or come to any conclusions about whether the developer gave you as Ms. Neenan said, I agree that would appear to be a civil matter maybe between you and the homeowners association and maybe even the developer of the subdivision. But notwithstanding, so yeah, I mean we have ZBA next Monday, so he's not on that one.
Right, no.
Right.
I think the soonest one he could get on is January, depending on whether he has the wetland delineations that are required or that the planning department is requesting of him, be that whatever documents they are requesting before they go before the ZBA.
Well, what, and I'm sorry, Mr. Lucius, did you have anything else that you wanted me to hear or any other testimony or evidence?
No, sir, that was it. Just that we're trying to get these issues corrected. As far as the area that's outside of my area, where we were given permission, lots 1 through 5 in the front of the neighborhood. What would we need to do there in that situation? Just have the homeowners association submit?
I mean, I can't give you legal advice. I'd probably sit down with an attorney
Okay.
and discuss with him or her what you have, what you don't have, and, you know, I'm not gonna tell you running the court's always the best answer or the cheapest answer. So, you may just wanna sit down and sounds like it might be an issue for several property owners. Y'all may all need to sit down with
Yes,
an
sir.
attorney and go
It's
over
lots
that.
1 through 4, definitely.
Yeah. So, yeah, I mean, if you're asking my advice is probably hire an attorney, and have them look at it with you to go over your rights. But as we sit here today, I'm more than willing, and I'll hear from the county, but I'll go ahead and put on the record, I'm more than willing to give you some time to try to work it through the system. What's the county requesting in this case?
Can I say one more thing?
Oh,
Your Honor?
sure.
So the original violation for landscape buffer, it said that I had removed items from the area. I have pictures from when the property was brand new. There was never a landscape buffer installed by the developer. And so the home was CO'd without a landscape buffer there. So that's just something to take into consideration as well.
Yeah, and I mean,
Because we did try to plant grass on that side of the home, and it died pretty quickly because of the shading, which
Okay.
caused runoff. That's why the pavers were installed, because it was causing, I guess you'd call it erosion with the sand that was there.
would and this is a question for the county, would the installation of the turf count as,
The issue also, I think, on this property would be the impervious surface ratio,
yeah,
being that most of the property in the backyard is turf and pavers. I don't believe that they will have the correct percentage to be able to keep any of or all of that, but that is ultimately up to the planning or the variance board.
yeah, you'll have to get
But-
with the county on that, or maybe the variance board, but
I think with the site plan showing that there is a landscape buffer there, I can't determine whether it was or was not put in before or after CO or removed after CO or
yeah,
anything of that nature. But the environmentalist Brad Bond did write in an email stating that that buffer would need to be restored.
yeah, and I mean, if that was the only thing, Mr. Lucius, then I think I would be inclined to try to suss through some of that this morning. I think you've got some other issues that also need to be cleared out, as far as some of the pavers and the encroachment and things like that. So, I mean, that's like one piece of a 6-piece puzzle
Yes,
that you're
sir.
dealing with. So while I could, even if I found that in your favor, you still got the other 5 pieces that are gonna ding you. So, with that being said, I'll go back to the county. What's the county requesting in this case?
60 days to achieve compliance or $250 per day fine to accrue with a $73 admin fee.
All right. And Mr. Lucius, what would you request of me? Understanding what you're trying to do and where you're at in the process.
Well, obviously, I don't know how long it's going to take to get the environmental study and the site survey done. So if we could have them a longer term period there, especially with the holidays going on, that would be great.
Okay. I'm inclined to do that. I will advise you that generally speaking, and you may have heard earlier about 120 days, that's usually not something I will do. Usually it's going to be 90 days. So I'm more than inclined to give you 90 days, understanding you're not just saying we're about to start the process. Sounds like you started the process
Yes,
with
sir.
the county. So, all right. Anything else from either the county or you, Mr. Lucius?
Do you
No,
want
sir.
copies of the pictures as well? Just so have
If you
them?
want me to have them, I can. I don't know that it's relevant, but I'll be happy to take them. All right. And did you want to just give me the pictures, or did you want me to have all?
You
this?
can have that packet.
Okay.
It's got information as far as the AIGS photos and everything that we discussed.
All right.
as
And
well.
this photograph is what you said was out there.
That
prior?
was what was there prior.
Okay, yeah, I see sod and.
I did install this side. Originally, there was only pine straw there, and it
Okay.
blew away within the first week of the house.
Understood. All right. Well, I'll accept this into evidence as respondents exhibit 1 composite. I'm going to put that up here. Let me mark this. All right, anything else? All right, at this time, I'm going to close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that based on the testimony and evidence presented this morning, there is sufficient evidence to find that a violation occurred. Oh, let me do this. I'll find that the property located at 971 Musset Bayou Road, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Land Development Code. The testimony that was presented does show that conditions exist to show a violation of 1.13.06 post-permit changes have occurred at the property and are that there is an ongoing violation. Based on the respondent's request, I am going to provide him with 90 days, the maximum amount of time. So when would that? March 10th. So on or before March 10th, Mr. Lucius. The property need to be brought in compliance. If the property is not brought into compliance on or before that date, there will be a $250 fine. What I will also tell you is even if you go past that, if you end up bringing the property into compliance, 20 days later, there will be fines imposed, but there is a mechanism you can work with the county on seeking a fine reduction.
Okay, thank you.
But the hope is that'll give you enough time, but I understand some of these things are out of your control. Regardless of whether or not the property is brought into compliance on or before March 10th, there is a $73 administrative fee. Mr. Lucius, that'll need to be paid within the next 30 days.
Okay.
And one other thing, because as I told you, I represent the Zoning Board of Adjustment. I kind of wear a different hat there. So if you end up going before the board and you think that you don't want me to act as the attorney for the board because of what's happened today, let the county know that.
Okay.
And then that way I can make sure that they've got somebody else up there. I want you to feel like you get a fair shake. I don't want you thinking, hey, he did all this and, he's going to try to ding me at that. So if you think that's going to be an issue, and it's totally your call, I'm not telling you to do it or not do it, but if you have any inclination that you think I might be biased, then I would just prefer to have somebody else handle that.
No problem. I appreciate your disclosure as well.
Yep. All right. Any questions, County? Mr. Lucius? All right. Mr. Lucius, thank you for coming in this morning. Have a good day. All right. Our next case is RAK Construction LLC, case number 2302547. This is a fine reduction denied. No. Let me find it. Oh.
Should be laid out. I don't think it's in a folder.
Oh, okay. Well, this one has fine reduction on it.
I think that's the last one.
What? Oh, here it is. All right. All right. Officer Neenan, whenever you're ready.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary in regard to case number 23-02547. The property is located at Kimberly Ann Drive, Santa Rosa Beach. Parcel number 30-2 south-20-33304-000-0100. Property owners is RAK Construction. This property is in an unincorporated area of Walton County and is subject to the Land Development Code Chapter 7 and county ordinances. The violations cited were 1.13.00A development approvals and 1.13.09F clearing permits and 4.0001 permits. On October 18th of 2023, this case was heard before you and you found the property in violation. The property owner was given until December 18th of 2023 to come into compliance. The property owner failed to come into compliance by the deadline given. An affidavit of compliance was completed showing the property in compliance as of October 28th of 2025 after a code compliance was notified by Brad Bond, environmental planner, that the property looked great. The total accrued fines come to $78,750 with a $23 admin fee.
So it was $250 per day and approximately, or not approximately, 315 days at that gives us our $78,750.
Let me retract. I said the property came into compliance on October 28th of 25. It was 24. I'm sorry, 2024.
Yeah, because that would be well more than 300
Yes, sir.
days. Yeah, I have, based on what was presented in my packet, compliance due by 12/18/2023, and approximately 10 months later or so, on October 28th is when the property, 2024 is when the property, $23 admin fee. Based on what you've presented, the county's recommending a 20 or 75% reduction in the fine.
Correct, yes, sir.
All right, which would be a 25% fine imposed of $19,688. And then with the 23 admin fee, you got $19,711. So that's the county's recommendation on the fine reduction.
Correct, yes, sir.
All right. What would Mr. Hunter, for RAK, what do you want me to consider?
Good morning, Your Honor. RAK is fine with that at a minimum reduction and just gives it to the magistrate's discretion as to increase that amount if need be. But as of now, we're completely fine with the county's reduction.
Yeah, I think I vaguely remember this. This was a long time ago, but part of it was because of the wetlands impact, and they had to come in and do a bunch of remediation.
Yes, sir.
Yeah. Okay. And I know that takes some time, so, I mean, I'm not I have no problem with the county's recommendation, and based on RAK's representative saying they have no issue with that recommendation. Okay. I see no reason to make it higher by any means. All right. Thank you, sir. Anything else from the county? All right. Thank you. All right. At this time, I'll close the evidence portion. I'll find that the property located on Kimberly Ann Drive, Santa Rosa Beach, Florida, parcel ID 32S23330400000100, was previously found in violation as identified in the October 18th, 2023 order for Land Development Code violations 1.1300, 1.1309F, and 4.00.01. Based on the evidence and testimony presented and the information provided, I do find that the property was brought into compliance on October 28th, 2024, based on the county as well as the owner's testimony and representation. I will reduce that fine from $78,750 to $19,688. There's also a $23 administrative fee for a grand total of $19,711. How long is it going to take RAK to make that payment?
We just asked for at least 60 days.
All right. Anything from the county on that? Okay. I will agree that the reduced fine will need to be paid within 60 days. So let's go to February 9th, so 61 days. So on or before February 9th, 2026, the reduced fine of $19,711, that does include the admin fee, will need to be paid. In the event that it's not paid on or before February 9th, 2026, advise your client that the fine will automatically go back to its original amount. So just make sure they get that paid timely. All right. Any questions from the county? Any questions for RAK? All right. Y'all have a good day. Thanks. All right, we've handled number 5. Are we, I know there's some other people waiting. Do we need to take a break, or are we good to press on? Everybody good to press on? All right, let's do it. CE 25-01695. Property owner is listed as lots 21-22 Georgie Street LLC, and the address is 135 Cabbage Rose Lane in Santa Rosa Beach. Is there anybody here on behalf of lots 21-22 Georgie Street LLC? All right, I don't see anybody. Officer Neenan, whenever you're ready, I'll find that. Go ahead.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony in regard to case number 25-01695. The property is located at 135 Cabbage Rose Lane, Santa Rosa Beach, 32459. Parcel numbers 27-2 South-19-24140-045-0210. Property owners listed lots 21 and 22 Georgie Street LLC. This property is in the unincorporated area of Walton County and is subject to the Land Development Code Chapter 7 and the county ordinances. The violations cited are 1.13.09 C building permits. On August 22nd of 2025, our office received a complaint stating overgrowth and construction junk and debris. On 8/25 of 2025, Code Compliance Officer Drew Galloway conducted an initial inspection and found a construction site near completion. On September 3rd of 2025, Code Compliance Officer Drew Galloway issued a notice of violation for overgrowth. On September 24th of 2025, this case was reassigned to me. On September 25th of 2025, I conducted an initial inspection and found overgrowth, and during research, I found that an approved planning permit had expired and the building permit had been released prior to a certificate of occupancy being completed. I spoke to Joe Harker. I believe he, according to Sunbiz, is a part of that LLC. And he said that he would get it cleaned up and contact the building department. On October 7th of 2025, I reissued a notice of violation with additional violations. On October 27th of 2025, I found that the overgrowth had been removed and construction materials stored properly. At this time, because the building permit was released, a new building permit would need to be issued, which is the only violation at this time. On October 29th of 2025, I attempted to contact Joe Harker with no response to find out the status of the permit. On November 17th of 2025, a notice of hearing was given as prescribed by code. At this time, I have not heard from Mr. Harker since that initial hand-delivered notice of violation, and by phone one time. Photos in the packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
All right, I'll accept that into evidence. It's my understanding, based on your testimony, that a CO still hasn't been issued, so they'll need to get another permit, get the CO issued, and close out that permit?
Correct, yes, sir. I believe there's additional inspections that need to be had before the CO is done, but at this time, because they've released that permit, now there's a structure on the property that has no permit at all.
Understood. I mean, from the exterior, it looks like a pretty house. I don't know what, why they haven't.
From my understanding with conversations with Mr. Harker, there was some financial issues that went into this build, and now it's currently on the market for sale.
Understood. All right. Well, what's the county requesting?
30 days to achieve compliance, or $250 per day fine to accrue with a $73 admin fee.
And just so I'm clear, this is only going to be related to 1.13.09C building plan or building permit?
Yes.
Okay. All right, thank you, ma'am. At this time, I'll close the evidence portion. I'll accept into evidence the packet presented by the county. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 135 Cabbage Rose Lane in Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find sufficient evidence to show that there is a violation on the property, specifically a violation of 1.13.09C building permits. Based on the county's recommendation, I will provide or order that the property be brought into compliance within 30 days. Remind me of that date. January 9th. 2026. Should the property not be brought into compliance on or before January 9th, 2026, there will be a $250 per day fine imposed. In addition to the fine, there's a $73 administrative fee that will need to be paid regardless of whether the property is brought into compliance, and it'll need to be paid within the next 30 days. All right. Our next case is CE 25-01479, Charles and Latresa and Lauren Gilly. Property address is 187 Shortcut Road in Freeport, Florida. We have Mr. Gilly here. This is a fine reduction. Let me find it. You can go ahead and begin.
Code Compliance Officer Justin Sloan, Walton County Code Compliance. This case is being brought for you for the matter of a fine reduction request for case 25-01479. Property located at 187 Shortcut Road in Freeport, Florida, 32439. Parcel number is 07-1S-109-23000-019-0000. The property owner is Charles Michael Gilly. The property is in the unincorporated area of Walton County, subject to Land Development Code, Chapter 7, and county ordinances. The violations cited were 7.02.02 overgrowth and 7.02.03 dilapidated structures. This case was heard before you on 8/13/2025. The property owner was given until 9/13 to come into compliance. An affidavit of noncompliance was recorded and an order imposing fines issued on 10/8/2025. As of November 19th, 2025, the property was brought into compliance. The county recommendation is to reduce the fine by 75%, which is $4,250 with a $23 admin fee.
Right. And remind me, this was, it said overgrowth? Is that?
Dilapidated structures.
Okay. And they just got the overgrowth under control. Did they remove the structure or they just?
Yes, sir. He got a demo permit and the structure was removed.
And then I have, based on what you testified to in part of this packet, so we had 68 days of the fine accrual at $250. So based on the recommendation from the county, 75% reduction would leave us at $4,250. There's a 23 admin fee. The county's requesting that's for a grand total of $4,273.
Yes, sir.
All right. Mr. Gilly, what do you want me to consider?
I just consider somehow I must have missed the hearing. I didn't get that one, but was out there in August actually clearing the property, cleaning the property, and had an altercation with the landowner behind this, claiming that what we were cleaning up was his property. And I have a report where the police was called out. Basically, long story short, they were asking us to give them some time to get them a survey to dispute my survey. I was giving them that time. In that process, this is when the fines were continuing to pile up.
Do you have that, or have you shown that to the county, like the report and that type of stuff? Have you seen that?
Yes, sir. Yes, sir.
All right. You want me to look at it, or do y'all? I mean, it's up to y'all. I mean, yeah, if you want me to look at it.
If it helps, for sure.
Well, it's up to you. I mean, I can take you at your word, or yeah, there's not a whole lot on this report. Okay, so like you said, there was a dispute between you and your neighbor. Property line dispute, 187 Shortcut Road. What ended up happening? Did it just take you a while to get? Did they even get a survey, or no?
When we went back out there to finally clear it, he had actually took his down, so I took it as he must have just give up, and he took that down. I just finished cleaning up everything else.
Okay. All right. Well, what are you asking for? I mean, you hear what the county, they want to do a 75% reduction. Are you good with that, or you want me to consider something else?
I would love to be considered.
Well, I understand that. What do you
But
want
I
me to?
mean, I'm at your mercy, so.
No, I understand, but I'm just, what do you think would be fair based on what you understand the facts to be?
I mean, I would love for it to be 90% reduction. I mean, I know I'm,
What's a 90% reduction look like on this? That'd be 1,700?
I,
That'd be 10% of 1,700. Okay. County, you got any comments on that? I know that's well more than you want, so. No, I understand. I'm not trying to play everybody off each other. But I'm also, it's not like the money's coming to me. So all right, I'm gonna, anything else from the county?
No, sir.
All right, anything else?
I'm okay.
All right, I appreciate that. I'm gonna close the evidence portion. I'll accept into evidence, this one-page police report, front and back. As part of this, I understand the county's position. I do find, that Mr. Gilly probably didn't get this done as quickly due to this issue with the neighbor. I won't do 90%, but what I'm gonna do is, and I don't even know what percentage this would be, but I'm gonna reduce the fine to $2,000 and add the $23 administrative fee, so it's gonna be $2,023. Can you get that paid in 30 days?
Hey, tomorrow,
Okay, well, you're gonna have to wait till they can get it. I don't know, y'all take the money over there. So it'll be $2,023. That includes your admin fee. All right, and then, I'll give you the same amount of time I gave the last person, 60 days to pay. Obviously, you can pay it sooner, but if you don't pay it within that time frame, it's gonna go back up to 17,000.
yes, sir.
All right, any questions from the county? Any questions from you?
No, sir, I
All right,
appreciate
great. Best of luck. And I've signed that order, so. Our next case is CE 25-01-532, James Caldwell. You guys have been here.
I feel like I know you well.
All right.
We learned so much.
Okay, well, sometimes it's good not to be the first one. All right, are you Mr. Caldwell?
I am.
Okay, so this property address is 1325 North County Highway 393 in Santa Rosa Beach, Florida. And I've got your case right here. All right, whenever you're ready.
My name is Officer Justin Sloan, Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony regarding case 25-01532, property located at 1325 North County Highway 393, Santa Rosa Beach, Florida 32459. Parcel number, there's two parcel numbers, 22-2S-220-33120-081-0080 and 22-2S-220-33120-081-0060. The property owner is James Caldwell. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. Violations cited are 1.13.00 development approvals, 1.13.09C building permits, 1.15.04 expansion of non-conforming use or sign. The complaint was multiple rusted shipping containers visible from the road and unregistered dilapidated van, trucks, and overgrowth. On June 17, 2025, I conducted an initial inspection and found Connex boxes that were not properly secured and an addition built onto the non-conforming structure that appeared to possibly encroach onto the neighboring property. On June 27, 2025, I sent a notice of violation with a compliance date of July 28th, to the property owner via certified mail and posted an NOV on the property. On August 20th, 2025, after confirming Mr. Caldwell owned both properties, I resent a notice of violation via certified mail and posted it on both properties with a compliance date of September 30th. While Mr. Caldwell has maintained communication and shown much effort in figuring out the best path for compliance was not achieved after granting an extension. On November 13th, 2025, I sent a notice of hearing via certified mail. On December 3rd, at a meeting with the property owner, I hand-delivered a notice of hearing for both parcels. This property was not brought into compliance within the allotted time. Proper notice was given. As of the last inspection date on December 9th, 2025, this property remains in non-compliance. I request the magistrate find the property in violation. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
Mr. Caldwell, you get a copy of that packet? You have
Yes,
any
sir.
comments or any issues before I accept it into evidence?
No, I think this is. Yeah, the only thing I'm not familiar with is the picture the city took yesterday.
Okay.
I saw them.
But that looks like your property in the photos.
It's my property.
Okay, yeah,
Yeah.
that's kind of stuff. I'm gonna accept it into evidence. I just wanted to give you an opportunity to, if you said, hey, that's not my property or whatever, then we'll deal with that. But I'll accept this into evidence. I do see the notice of violation. There was one notice of violation that didn't have both parcel IDs, but this one that I'm looking at does have both parcel IDs ending in 0080 and 0060. We've got several violations. One's 1.13.00A, development approvals. The other is 1.13.09, building permits. And then I've got another one, 1.1504, expansion of non-conforming use or sign. Walk me through, I get the Connex boxes that I can see in the photographs. And then I also see, is it this blue vehicle that has the wooden back that's the dilapidated vehicle that you
No.
were mentioning? Okay.
That picture was just for the house.
Oh, okay.
There's a van on the other side of the. It's not a dilapidated vehicle. It's a
Okay.
work van.
Understood. So what are the walk me through 1.13.00A development approvals? Is that there's some unpermitted structures on the property?
Yes, sir. So there was an addition to the pole barn on the left side of the property.
So I've
That was
got, I see a
non-conforming.
picture with some blue roll-up doors to the left, and then I see.
Right, so that structure is non-conforming, but he built onto, it built like it was an apartment.
Right.
To the right, there's like,
sir.
it looks more like,
25
it's got
years
some
ago.
white siding or something like that.
Right, yes, sir.
Under that same roof structure.
Yes.
Okay, so that's what the county's alleging is the non-conforming building.
Yes, sir.
All right. What else do I have? That would need building permits and also development approvals, right?
Right.
Okay.
And that's the expansion of the non-conforming use.
Okay. Is that all we're dealing with this morning?
Yes, sir. There's also another structure behind that, the blue vehicle.
Oh, where you just see the top of it?
Right.
Okay.
That doesn't have permits.
So that's been unpermitted?
Right.
Okay. All right. And you've made contact with Mr. Caldwell regarding these? What's he told you as far as these structures or these things? Anything?
I can give you
That's fine. I just was,
I'd
yeah,
rather
hold
let
on
him
one
speak
second.
on that.
All right, so you don't have anything to add. Have
No,
you
sir.
had any contact with him?
Yes, sir. I have.
Okay. All right, well, I'll let Mr. Caldwell fill in those gaps. Mr. Caldwell, do you have any questions for Officer Sloan?
no, the only question I would have is related to the difficulty I've had in getting the various departments at the county to respond to me in a timely manner.
I don't know that he's going to be able to tell you the
No.
answer to that.
Well, I've asked a lot of people, and nobody's come up with an answer. So I just want to make it a matter of record.
Well, you can. Like I said, this is your chance to ask Officer Sloan any particular questions about his investigation or testimony this morning. So if you have a question, go ahead and ask that now, but then
Okay.
I'll let you put what
You would
want.
agree that this is a complex case
Oh, yes, sir.
based on multiple outcomes
Yes, sir.
depending on different courses of action.
Right.
That's enough for me.
Okay. All right, Officer Sloan, you can grab a seat. Mr. Caldwell, you can stay there, or you can come up to the podium, whatever you want want to do, and I'll hear any testimony or evidence you want me to hear.
I'm not sure. I would like an extension in order to resolve this. I think I have a plan of action. After our meeting with the building inspector the other day, which was 2 months after I submitted the evidence to him. I really don't, I have no issues with code enforcement because they've been fair with me and responded in a timely manner. I'm just concerned that the course of action that I'm currently pursuing, which requires some additional permitting, things like that, gets done before the term of an extension expires.
No, and that's always an issue for every case. You know, I've only got certain amount. I can't just give infinite amount of time or anything like that. But I'm more than willing, especially if I see that the property owner's making strides to do something. I think it's the other side of the spectrum when you have a property owner that hasn't done anything for a very long time, and then they want to come in and now give me more time, and you're questioning, well, what have you been doing with all this other time? Because oftentimes these things don't come to me, you know, they cite you on a Monday and you're here on a Friday. It's usually they cite you months ago, and then 4 to 6 months later, even longer sometimes, before it gets, you know, to this point. But I'm more than willing to entertain to get you guys some additional time. Sounds like you're working to try to get something.
I think I have a course of action now that's been defined by, although it took forever to get there, it's been defined by the appropriate people in planning and building in the building department.
Okay. Well, I mean, you heard me earlier. Like I said, you guys have been here almost as long as I have, probably longer. This morning, I think you were here before I got here. So the, you know, usually 90 days is kind of my limit to give. I'm not suggesting that you're going to be done with the county in 90 days, but you've also had the opportunity to see that you can come in and ask for a fine reduction in the event, you know, fines accumulate, and, you know, we'll deal with that at that point if that becomes an issue for you. But, let me ask the county, do you understand that Mr. Caldwell and those guys are trying to get this resolved through county means?
Yes, sir, we do.
All right. What's the county's recommendation on this?
Recommendation is 90 days to achieve compliance, which is March 10th, or $100 day per fine to accrue with a $73 admin fee.
Okay. Mr. Caldwell, you heard what the county's recommendation is. That's basically the max I can give as far as time goes.
That seems fair.
And $100 per day if you can't get it done by March 10th. Like I said, there is a procedure, you know, if you shoot past that.
Right.
And if it's the county's fault, come in and tell me that, you know, at the fine reduction. We'll deal with it at that point.
Can I bring one other thing up, just, and I don't want to draw this out. I'm preceding my next door neighbor, Linda, who's coming up here. There's been overtures made from us from anonymous sources to purchase our properties that we've never received before.
Okay.
Make that a matter of record in this. And that's more of a, if there's anything involved in that, that's more of a, that's not a civil matter. So just something to consider.
Yeah, I don't know what I can do with that information.
I don't think you can do anything.
Yeah.
But I just
no, and I mean, there may be people out there that look at these things and think, hey, maybe I can get a good deal or a cheap deal or whatever. I don't know. I would just be cautious of that, obviously.
Or perhaps they're complainant.
Could be. Yeah, I don't know.
Or a developer.
100%. Yeah. All right. Anything else from the county or from you, Mr. Caldwell, that you'd like me to consider?
Perfectly happy with that, and I've been treated fairly.
Okay. Well, that's good to hear. I always like to hear that versus the alternative. All right. At this time, I will close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 1325 North County Highway 393, Santa Rosa Beach, Florida is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I will note that there are two parcels that were brought before us this morning, ending in 0080 and 0060. They're both owned by Mr. Caldwell. Based on the testimony and evidence presented, I will find that there is sufficient evidence to show that there's a violation of the Walton County Land Development Code, specifically 1.1300A, 1.130.09C, and 1.15.04. Based on the county's recommendation and Mr. Caldwell's testimony, I will provide the property will be brought into compliance on or before March 10th of 2026. In the event the property is not brought into compliance on or before that date, a $100 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee. That'll need to be paid regardless of whether the property is brought into compliance, and you'll have 30 days to pay that, Mr. Caldwell. Is that going to be a problem?
No, sir.
Okay. Did I miss anything from the county?
No, sir.
All right, Mr. Caldwell, did you understand the order as?
I do.
Okay. I appreciate your patience and being here. Thanks for, spending
It
your
was
time.
an learning experience.
Yeah, I know. Painful one usually. So I've signed that order, and best of luck to you, sir.
Thank you, sir.
Yep. And then now we've got Barton Living Trust, and that's 13.
Linda Barton, yes.
Miss
sir.
Barton, how are you?
Tired.
I bet. So Miss Barton, the property is 1389 North County Highway 393 in Santa Rosa Beach, Florida.
Correct.
All right. Officer Sloan, this one yours too, it looks like.
Sir.
All right, go ahead.
My name is Officer Justin Sloan, Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony regarding case 25-01623. This property is located at 1389 North County Highway 393, Santa Rosa Beach, Florida, 32459. Parcel number is 22-2S-33120-081-00040. The property owners is Barton Living Trust, is Miss Linda Barton. This property is in an unincorporated area of Walton County and is subject to Land Development Code Chapter 7 and the county ordinances. The violations cited are 1.13.06 post-permit changes. The complaint was multiple unpermitted structures, property line encroachments, dilapidated structures, junk, debris, and commercial art gallery activity. On July 24th, 2025, I conducted an initial inspection and found an arbor in the county right-of-way and an addition to the back porch of the home. On July 29th, 2025, I sent a notice of violation with a compliance date of August 30th to the property owner via certified mail and posted an NOV on the property. On August 19th, 2025, the arbor had been removed from the county right-of-way and the property owner had applied for a BPR. Planning advised the property owner that the back porch was in the rear setbacks and they could not approve her application until she either removed this portion or obtained a variance. On October 29, 2025, I conducted a follow-up inspection and found some of the porch had been removed. I advised the property owner to provide a survey showing the porch was not in the setbacks or how to obtain a variance. On November 13th, 2025, I sent a notice of hearing via certified mail, posted a notice of hearing on the property, and posted a notice of hearing at the courthouse. On December 2nd, 2025, a pre-app meeting request for the variance was applied for. The property was not brought into compliance within the allotted time. Proper notice was given. As of the last inspection on December 9th, 2025, this property remains in non-compliance. I request the magistrate find this property in violation. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
Ms. Barton, I'm going to accept that into evidence. Do you have any issues with me doing that?
No,
All right, thank you, ma'am.
Just a small correction. It wasn't the code department requesting a survey. It was the planning department to approve her BPR.
Oh, okay. Well, yeah. So the only one that we're dealing with today is well, let me ask this. So it looks like there were two issues at one point. The post-permit changes, that was the porch from rear of house.
Yes, sir.
and remove connector port from main house to rear left house or obtain BPR. And then we had a right-of-way agreement issue. Has that been resolved?
Yes, sir, it has.
Okay, good. So all we're dealing with is 1.13.06. Ms. Barton, do you have any questions for Officer Sloan?
No, I just got the survey,
Okay, good.
and the survey did not show what they wanted it to show.
Okay, that's bad. All right.
That's not good. So then, I didn't have enough time before they issued this, which I thought was a variance meaning. That's how uneducated I am. And so then I went to the survey, and then they put the exact measurements on it. So I have a reference point so that I can do the cutoff of the patio.
Okay. So you just need some time to,
I just need
okay,
your 90-day,
my standard 90 day?
your
or-
standard
okay.
90-day
Oh, that's good.
thing.
Okay, well, let me ask, what the county is requesting.
County recommendation is 90 days, which is March 10th, to achieve compliance, or a $100 a day per fine to accrue with a $73 admin fee.
Okay. And Ms. Barton, you're pretty confident you can get it done in the 90 days?
I think I'm pretty confident, Judge.
I'm hopeful. I mean, and, you know, in the event that you run over, as I told Mr. Caldwell and some others, you know, there's a mechanism.
I know this bill, yeah.
Yeah, so, all right, well, unless there's something else, I'm gonna try to get Ms. Barton and Mr. Caldwell out of here. Anything else from the county?
No, sir.
All right. Anything else from you, Ms. Barton?
No,
All right, I'm gonna close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the.
One
Well,
thing.
hold on, let me reopen the evidence portion.
Okay.
What do I need to hear?
This has to be if I comply with this, this is that's it, no more.
Yes, ma'am.
Okay,
Unless you go do
I just
something.
want that in the record.
Yeah, unless you go do something else, they gotta bring that back to me, but that'll be a whole different case. All right? All right, I'll reclose the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that property located at 1389 North County Highway 393, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. That based on the testimony and evidence presented, there is sufficient evidence to find that there is a violation of the Walton County Land Development Code, specifically 1.13.06 post-permit changes. Based on the county's recommendation and testimony by Ms. Linda Barton, I'm going to provide the maximum amount of time, which is March 10th, 2026, to bring the property into compliance. Should the property not be brought into compliance on or before March 10th, 2026, a $100 per day fine will be imposed. There's, in addition to the fine, a $73 administrative fee. Ms. Barton, can you pay that within 30 days? All right, thank you, ma'am. So we'll have that admin fee paid within the next 30 days. And I'm signing that order now. Miss anything from the county?
No, sir.
All right, Ms. Barton, you understand?
Yes, sir.
All right, best of luck to you as well, and have a good day. Y'all can get out of here now.
Ready?
All right.
I'll meet you at the truck.
I'll probably walk
Say
over there
again?
with you. I'll be there in a minute. Thank you.
Oh, okay. Yeah, I'll do that one. All right. I think our last case is Mr. Michael Castle. I don't see anybody here for Mr. Castle. This is address East Mac Bayou. There it is. And this is Brown.
It wasn't a folder, a yellow folder.
Oh, it's in one of these.
Or fine reduction. Yes.
Okay. All right, whenever you're ready.
Code Compliance Supervisor Jennifer King, Walton County Code Compliance. I am coming before you today regarding the matter of a fine reduction request for case number 22-01541. The properties are located on East Mac Bayou Drive in Santa Rosa Beach, 32459. The parcel numbers are 242S21 420000110020. Then there's 24-2S-21-42000-011-0010 and 24-2S-21-42000-011-000. The property owners listed as Michael Castle. The property is in the unincorporated area of Walton County and is subject to Land Development Code Chapter 7 and county ordinances. The violations cited were 1.13.09E clearing permit, 4.03.03 bayshore protection, 5.04.06 right-of-way agreement. This case was heard on April 17, 2024. The property owner was given until July 16, 2024 to come into compliance. An affidavit of non-compliance was subsequently recorded and an order imposing fines was issued on August 14, 2024. Due to oversight and lack of communication, it was not known that the property had come into compliance until December 4th, 2025. Although it is the property owner's responsibility to notify the code compliance department and request a compliance inspection as soon as they believe compliance has been achieved, the county acknowledges that it could have discovered the compliance either before or shortly after the magistrate's compliance due date. Therefore, the county recommends a full elimination of all accrued fines, which totaled $25,300. However, we request that the $23 administration fee be imposed. The property owner has already paid all outstanding administration fees associated with this case.
Okay. Yeah, that is unusual. All right, so county's request is to reduce this to 0, but keep in place the $23 administrative fee for prosecution. Are you going to transmit that to the property owner so they know they
Correct.
need to
He
pay
was
that time?
in DC today, so he couldn't be here.
Understood. All right. Based on the county's recommendation and the evidence and testimony presented, I will reduce the fine to $0. And you already have it in here under sub 6. Defendant, says defendant, but we'll just say respondent shall be responsible for costs for prosecution of this case in the amount of $23. That'll just disadvise him. That'll be paid within 30 days. Because the fine's reduced to 0, I'm not going to have the same provision that if he doesn't pay the $23, that it's going to go back up to $25,300. That seems a little heavy-handed. So if you'll just make sure property owner understands that, I've signed that order, and I'm putting it back in this envelope. All right?
Thank you.
All right, the remaining things are orders that I need to sign, so I'll do that offline. Anything else from the county? All right, we're adjourned.